I'm reading a media statement released by SAGA regarding the Firearms Control Act, the Bill of 2025, an update. Reports indicate that Cabinet will receive the bill in March 2026. The South African Gun Owners Association has received credible reports from a recent Business Unity South Africa, BUSA, meeting attended by attorney Martin Hood that the Firearms Control Amendment Bill, FCAB 2025, is expected to be submitted to Cabinet in March 2026. This seems to indicate that public participation, expert engagement, and formal processes, including NETLAC engagement in December 2025, and the 118,000 public submissions back in 2021 are potentially being effectively disregarded. More to follow soon on this breaking story. In tonight's episode with SAGA, we're going to be talking about a recent High Court judgment against the Firearms Registry and its staff. Very interesting situation indeed. And I'm talking to Shaun Lyle, one of the board members of SAGA. Shaun, good evening and welcome.
Good evening, Rian. Thank you very much again to be on the podcast. It's certainly a pleasure, as always.
Shaun, we've got a lot of ground to cover with this one regarding this case against the Firearms Registry. So let's jump straight in. You refer to it as the Marksman Arms. Why do you see the 2 February 2026 Marksman Arms as such a significant date in the whole firearms debate?
There's a pattern of these cases, but this one has been quite conclusive. In this case, the Gauteng High Court ruled against the CFR and SAPS, basically saying that they are not above the law. And it wasn't a technical dispute. The matter wasn't about a technical dispute, but rather about a constitutional rebuke, or their rebuke of the FCA administration or lack thereof. And what the court did was set aside the CFR's decisions, and it ordered compliance with the Act. And I'm sure we're going to talk a bit later about a couple of other very interesting things that came out and were stated in this judgment. So, yeah, very, very interesting case. Like I said, it's not the only one. There's a pattern of them, but it's become quite specific in what it's saying. And that's, I think, setting a precedent, very, very clearly set out in this judgment. So it's fundamental.
And a positive
way for us, yes.
For correct. The firearms community. So let's talk about the judgment itself. You described this as a constitutional rebuke rather than just an ordinary judicial. I am falling all over these words tonight. Review. In your view, what has made the court's findings about the CFR so serious?
Well, basically, what they're saying is it's confirming systematic failure and not isolated incompetence. So Ian Cameron commented on it as the chair of the Portfolio Committee on Police, and said that this is a judicial finding of institutional breakdown. It's not firearm owners complaining and whining, but it's actually a finding on judicial breakdown. And the court addressed the legality of the power of the CFR. So this is not mere inconvenience now for firearm and firearm dealers. They're now going to constitutional effects to say that we are having our rights abused. So you can understand other cases dealing with more technically related matters, but this one is all to do with incompetence. And I'm sure we'll get to a point where I'll actually quote what the justice said. Two specific statements that are actually damning on the competence of the CFR. So it's fundamental for that reason. It's not a flash in the pan. It's something quite profound that's been said.
Well, the court used quite a bit of strong language here. So before we get to the gist of that, why do you think it went that far?
I don't know if it's been a long time in the making, and because of the abuses, inverted commas, that have been thick and fast on the ground, that the courts are now starting to look at this pretty much similarly to what we were saying in the American context with the Heller Bruin, and are now pushing back. We certainly hope so, and certainly from the tone of the judgment and the ruling, it would seem that that is the case. So from our point of view, it's long overdue that the constitutional matters like this are actually put on the record, and there's a pushback. We can't be continually dealing with excuses of lack of capacity from the CFR as if that sorts out the legality, because it clearly doesn't. And I'm sure I'll have an opportunity to mention a little bit more on that a bit later. But that I think is really the gist of it. So it's actually quite fundamental, this case.
So at what point does repeated litigation against the regulator become a proper governance problem?
I'm not sure. I would hope sooner rather than later. And certainly, again, the tone of this particular case is starting to point in that direction. So I think time will tell now. If we start to get more judgments coming out with this particular tone, that will certainly give us a very clear indication. And I can say from conversations with Martin, effectively saying there are more to come, quote unquote. And I think that's going to be interesting. So I think it's going to start to speed up. Certainly, we hope so. We certainly hope it's going to speed up and point in this direction. Absolutely.
You mentioned just now the Heller and Bruin situation from the US. Can you just maybe expand a little bit on that? Why do you say that's relevant to South African constitutional law? And talking about constitutional, in the same breath, are you saying the CFR has effectively reversed the constitutional burden of proof?
I think what the CFR is doing is inverting the whole scheme of things. So in the American Heller Bruin, and we're not saying that we're trying to import, I think we had that in our discussion, American jurisprudence. We're not trying to import that. But the concepts in the Heller Bruin framework were and are constitutional. And it certainly articulates constitutional logic that is already in our law. And that basically is that rights exist before regulation, and the state bears the burden to justify any limits on those rights. And that's got to do, and certainly with us, with the PAJA Act, which is the Promotion of Administrative Justice Act. And that's certainly a big part of this whole process. So things like unlawful backlogs, changing procedural things on the run, which the CFR has done, effectively denies rights. And our interpretation of this particular case is that that is what it's making a judgment on. In the broader sort of strategic context, it's making a judgment on that, which is exactly what the Heller Bruin case or framework did in the States. So it's talking to constitutional issues, and in summary, the CFR is basically inverting the whole process. We are having to go to court to prove rights and to secure administrative justice, and that is not what the process is for at all. So it's complete inversion of the way it should work, the way we would rationally imagine this to work in terms of a constitution.
You talk about a bitter irony in public safety. What do you mean by that?
Well, from a law-abiding citizen point of view, as firearm owners, whether you're section 13, 15, 17, or 20, we've got to jump through fiery hoops. Training, competency, proficiency, background checks, fingerprinting, inspections, renewals, laborious dealer processes that are forced upon them. Yet our criminal class comply with absolutely none. They use corruption, they use influence, they use organized crime. So what we're seeing now is the system is punishing obedience, but not lawlessness. So this is a governance failure. And there were specific comments along those lines in this judgment. This is not about gun control or gun regulation. It's about a competence issue. It's about government failure. And it's hypocritical that we are punished as firearm owners, having jumped through all of those hoops. But the criminal class carries on without any regard whatsoever. And that to us is very ironic.
So in all of this, there's obviously always a cost to the public. What are the SAPS contingent liability figures, and what do they tell us about the broader system?
Okay, so I think the key thing from a lawful citizen perspective is that we are paying twice. We are paying the legal costs of having to go this route to enforce administrative justice, number one. Then the state is deciding to defend rather than fix the system. And they just use taxpayers' money to pay the legal costs from their side. And those costs are coming from the citizen. So effectively, we believe the citizen is paying twice. And the numbers are massive. Per parliamentary questions to the acting Minister of Police on record, he stated that the contingency, in other words, matters not yet decided by respective courts in terms of claims against SAPS, sits at 50-odd billion, 52 billion rand. And if we look back at the costs of unlawful arrest and detention powers, just those, not all the costs, just those specifically, if I can quote those, 22-23, 541 million, 23-24, 491 million, 24-25, 620 million, and for the year to September, in other words, half the year, 301 million. And so that's not all the costs. Yeah. So it's increasing dramatically, double-digit increases. And then we're told we have a potential contingency of, on top of all of that, another 52.7 or 52.6 billion rand. So we are, as a country, hemorrhaging money on things that should never go to court, shouldn't have to go to court, and we shouldn't be paying for it twice. Because counsel for the citizen, law-abiding citizen going to fight these things is high. And then we've got these abuses thrown at us. And these aren't really mentioned. I mean, they're readily available, but no one really talks about them. It's not millions, it's billions. And it just keeps ramping up. And that's just the last 5 years. So it's an alarming situation.
You call this an unlawful administration in that respect. And the fact that taxpayers are now paying, well, they're paying double and more for that, just to force the administrative system to do the job it's supposed to do in the first place.
Correct.
It's wrong on every single level, but the bureaucracy, certainly, they don't seem to mind.
No, because they're not picking up the tab.
Exactly.
And I think our heads would spin if we started to look at this across state in general and just add up what state refers to as wasteful and fruitless expenditure. This is just part of the SAPS legal litigation on unlawful arrest and detention. It's not all of it. So, yeah, and that's in one state department. I mean, it's just absolutely mind-boggling. Very difficult to wrap your mind around these numbers. They are absolutely massive.
So, safe enough to say that it is systemic. And if so, if you agree with that, where does the responsibility lie ultimately? CFR, SAPS leadership, Parliament?
Yeah, I'd say it's a quintessential definition of systemic. It's just unbelievable. And I think if we frame that in what must change, your question, where does the responsibility lie? I'd frame that as what must change, because this is unsustainable. We would say that the Parliamentary Portfolio Committee, because they're tasked with oversight of SAPS and the CFR, they need to seriously look and urgently at the whole CFR decision-making process. That's the first thing. They need to look at compliance with the Firearm Control Act and with the PAJA, Promotion to Administrative Justice, of which this is a classic example. Leadership needs to be held accountable. They're not held accountable. They may be responsible, but they're not held accountable. And this case is very interesting because the judge in this case went to the point of wanting, or at least mentioning, that the officers specifically involved in this decision-making or lack of decision-making should be held personally responsible for the legal costs of this case. Then went on to say he will give them the benefit of the doubt and he won't do that at this stage. But he made a clear warning that that's where the courts are going to start to go. On top of that, He then went further to say that the registrar has to bring this to the attention of the Minister of Police or acting Minister of Police, and that's in the written court judgment. So
why is that?
They are putting pressure, or the court is now putting pressure on the leadership to be held accountable for the actions they take. It cannot just keep bouncing back to the taxpayer or the state purse to cover these things. So that is, I think, an important point. Disciplinary consequences have to follow unlawful conduct. And this is the closest we've ever got to a statement or a series of statements in a judgment saying that the conduct is unlawful. He actually went on to say that officers, the officers in this particular case, should know better than to follow unlawful orders or instructions, because they tried to argue that they were ordered by superiors. And for a judgment to come out and say categorically in a statement, I'll try and find it shortly for you, this is not how this should work, and you should not fulfill an order that you know is not in terms of the legislation. And that was in itself interesting. So the very fact that the court in this case has directed the registrar to brief the minister and the national commissioner is in fact a rare thing. It's quite unique to have that in a judgment. So clearly the ante is increasing and the pressure is up, and this is the sort of pushback that's coming. And I think part of that could be that he also wanted to find the brigadier in contempt of court, because those senior officers left the court before the court case was finished. And that did not sit well with the judge. Left the officers there, but they left the precinct, both of them involved and named in this case. And I think that went down particularly badly. So those would be the items, the points that we would raise, that we would expect to come from something like this, particularly if there are going to be more cases, and this is where the court is going to lean. Then I think we're starting to point in the right direction.
You mentioned earlier that you may want to address some of the specific things that came up in the judgment. If you've got something that you would like to maybe read to the viewers, let's do that.
Yeah, I'd like to just cover two very brief statements that were made. They were made in para 17 of the actual judgment itself, which is, I think, 9 pages in length. And I'm going to quote two statements that the judge made. Number one, I quote, blatantly obstructive and contemptuous, written in the ruling. And number two, showing an astounding lack of knowledge. So those were two specific statements. What the CFR did is, number one, they refused a lawful responsible person change. So it was a dealership, the sale of a dealership, but the sale of the company itself, not a change of company. And they refused to do that. They then invented requirements not in the FCA. They shifted their own criteria mid-process. They conflated close corporations with companies, which is where the statement showing an absolute lack of knowledge comes from. They mixed these two entities up completely. And then they continued to persist with unlawful positions even after the court had intervened. So for a judgment to have those two quotes written in it is refreshing, but it's not that common. So blatant obstruction and contemptuous action, and then showing an astounding lack of knowledge of their own processes, their own law, and of company law in terms of this particular matter. So it should never, ever have gone to court. In the same way that the case before that with the SA ammo and arms dealers with the barrel serialization story.
Yes.
Absolutely ludicrous. That should also not gone to court. So, but this time, in a step forward, we're getting the statements being made categorically. Previously, those were implied. You could read them between the lines. Now it's in black and white, in this case, in clause 17 of the judgment.
Well, let's hope that is a new direction that the courts are taking in an effort to start stamping out this level of absolute gross arrogant incompetence.
Yeah, it just brings to mind a quote from the late Neil de Beer.
Mm.
He said, "The worst kind of stupidity is arrogant stupidity."
Yes.
And I think it fits very well here. So there are two issues, I think, in this. One is the incapacity and the other is incompetence. Now we can add a third, complete lack of knowledge. And what the court is basically saying, that the CFR's administrative incapacity, because we hear these excuses from SAPS also. No, we couldn't attend, we couldn't do X, Y, and Z, we don't have vehicles, we don't have resources. And what the court is now finally starting to say is that is an excuse that's not our problem. You have a constitutional duty to the citizens of a country, and you are not going to get away with these things by saying, oh, we didn't have the administrative capacity. And then in this same court case, they referred to complete incompetence and violating their own internal procedures, and then walking away before the judge has even given the final ruling. I mean, it's absolutely astounding. It's astounding. So I'm surprised that more hasn't been made of this case, but guaranteed this is going to be a case study. Ian Cameron, the chair of the Portfolio Committee, put out a very good statement along the lines of what we're discussing. So it's certainly being picked up by the right people, and I think it's going to give us good mileage.
On that point, talking about the police, of the Portfolio Committee on Police, do you think they should be doing something differently at this moment in time? And if so, what?
No, I think they're doing the right thing, certainly under Ian's chair. I just think it needs to, and there's a lot going on. Admittedly, there's a lot happening in that particular portfolio. But we just think that there needs to be a lot more attention on it. And the very fact that Ian picked up very quickly on this judgment, and it basically gave an excellent synopsis, and we quoted some of his statements earlier, I think is exceptional. So it's clearly not being ignored, but we would expect now for things to really start happening off the back of this. So yeah, in principle, I think they're doing an excellent job. They've got a lot happening on all fronts. They're fighting on many fronts, but this is, I think, going to give them impetus to really start pushing, which I think is exceptional.
Okay, so in closing, Shaun, if you had to reduce this to one simple truth for the viewers, what would that be?
Well, it would be modeled off what appears to be punishing obedience and rewarding disorder, and a complete constitutional failure that Parliament is ignoring. So that's a big concern. I think the moral of this story is that incompetence is protected and rewarded, and crime clearly pays. But maybe those days are now up, because constitutional failure that is ignored by Parliament is completely unacceptable. So I think in summary, that would probably put a cap on it. I think that's where we're sitting at this stage, our review of it.
Okay. Well, for the viewers, we live in interesting times. There is info on the SAGA page about this specific case, this judgment that we were discussing. As I said, there will be more to follow on the intro that I was leading with about the Firearms Control Act bill, that seemingly they are now pushing to get that sorted or in process by March. We will be keeping a close eye on that. And as always, if you like the video, please click the like button. Please subscribe to the channel, help us grow. It's great for the algorithms on YouTube, for the visibility of the channel. And smash that bell icon so that you can get notifications of all our new videos coming out. And as always, in the description below, a link to all the information on training available. Check it out. We look forward to meeting you on a range one of these days. Shaun, that's it for me. Thank you so much for spending some time with us.
No, it's only a pleasure, and we are sure to bring you a lot more if this is anything to go by. So thank you again.